right, so Chapter 7B, Leasing Real Property. We're going to start off with the condition of the premises as Teddy and Kenny fight or play in the background. All right, so substandard housing, it can have a real impact. Not only, is it pretty deplorable, some of the conditions that we'll read about, but they can cause impairment to children, physical and mental impairment, and even death in some cases. So Emory Clark is a pretty graphic case. It introduces you to the problem of substandard housing, and it gives you some examples of tenants living in pretty shocking conditions. And the purpose of placing this case in your reading is twofold, really, to kind of try to get you to think about how could this happen, and then you also try to think about how the law can prevent this. So in the 1960s, there was a bit of a landlord-tenant revolution where public interest attorneys did their best to try and change the tide and make it so that there were some protections for tenants. Now, I'm not going to spend too much time on Emory Clark, but I think it's important to understand that although it is true that residential tenants, technically have a right to negotiate, we have all received leasing contracts, and we know that in actuality, there is no ability to negotiate. There are form contracts, and tenants don't have that much power, whereas the landlords do, because they control, and they're able to get together and come up with form contracts that we all then have to comply with. Now, I already mentioned some of these questions, but if you think about, like I said, any leases that you may have signed before, and if you were able to negotiate any changes, oftentimes you might be able to negotiate some, but usually there's not much room for negotiation. Okay, so sometimes the conditions in a property can be so bad that it was as if the landlord evicted the tenant. So this doctrine is used it came before the doctrine of implied inhabitability, which we're going to go over later, but this was the first doctrine that was used to protect tenants. It also is still used in commercial dealings. So what is constructive eviction? It's when a landlord's act of making the premises so unfit for occupancy, it results in the tenant being compelled to leave. It's so bad in there that the landlord has made the conditions so bad that the tenant has to leave. Now, the reason why this wasn't used a lot, or it was difficult to use in the residential setting, is because to assert constructive eviction, the tenant has to actually vacate the premise. And so that makes it difficult to use, because to be able to assert it, you have to leave the premise. So let's talk about Fidelity Mutual Life Company versus Kaminsky. This case introduces the constructive eviction doctrine in kind of relatively interesting way, I guess. So Kaminsky was a gynecologist, and his practice included the performance of elective abortions. He entered into a 2-year lease tenancy with Fidelity Mutual Life Insurance Company that owned the building. The lease had an express covenant of quiet enjoyment, and and anti-abortion protesters began demonstrating on the property about a year after the tenant started using it. So the protesters were both outside the building and inside the building. They were also on the staircases. They prevented patients from entering the building or the office. So the lease required Fidelity to provide security, but on Saturdays they did not. Kaminsky complained over and over again, and neither Fidelity nor their management company did anything. Kaminsky tried to call the sheriff to get them to vacate the lobby at one point, but the sheriff noted that he didn't have the authority that they needed the managers to do that. So anyway, Kaminsky vacated the premises in December of 1984, and Fidelity sued to recover the rent due. The jury found that Kaminsky had been constructively evicted, and the Texas Court of Appeals affirmed. And so now the case was being reviewed. Now, there's kind of two real central issues that come up when you have a case of constructive eviction. The first is, when does a landlord's omission trigger the doctrine? So not all of the landlord's omission or failure to act is going to trigger this doctrine, but some will. So one of the central problems is, when does the landlord's omission trigger the doctrine? The second issue is, what is substantial interference? What level of interference with the tenant's use of the premises is going to be high enough to trigger the constructive eviction? So let's talk about the first, the omission by Fidelity. Who actually interfered with Kaminsky's practice? So it wasn't Fidelity that was actually protesting or picketing or physically blocking access of his patients to his office. It wasn't a representative of Fidelity, or it wasn't one of their rental or real estate agents. So why would Fidelity be held liable for the actions of the third party, for the protesters? Well, the reason is because Fidelity had the power to control the protesters' access to the common areas, to the stairwells, to the inner lobby, the atrium area. They could have ordered the protesters to leave. They could have ordered the sheriff's officers to escort them off of the premises, but Fidelity did nothing. And Kaminsky, like I said before, couldn't control who entered the common areas. Only Fidelity had that power. So then we move towards substantial interference. Did the protesters totally prevent Kaminsky from conducting his medical practice? Well, no. He was able to practice medicine every day except for Saturday, when he conducted the elective abortions. Well, did he lose patients because of them? He might have. The demonstrators were found to have often occupying the stairwell or blocking the doorways. And a medical office can't function if patients are unable to get through the door, right? So I think that even blocking access one day a week is sufficient to reach the substantial interference. And that is what the court found. So the court found that the landlord's omission triggered the constructive eviction doctrine, and that there was substantial interference. Okay, so although the general rule is the landlord's not responsible for the action of third parties, it applies only when the landlord does not permit the third party to act. We discussed these already, so we'll go ahead and skip over them. Okay, so the next case we're going to discuss is JMB Properties Urban Company versus Pallucci. Pallucci, I think. So this is another example of constructive eviction doctrine, and the facts of the case are as follows. So Pallucci opened up a jewelry store in the mall in 1978. In 1984, the video store moved next door, and they both shared a wall. Immediately, Pallucci began complaining about the high level of noise, and in 1986, this didn't prevent him from entering into a new 6-year lease. Apparently, the new building owner promised that the noise problem would be taken care of, and Pallucci argues that based on that assurance, he signed a new lease. So the noise created a lot of problems. Customers complained. Pallucci himself filed 500 complaints with mall management. So the Barretts left in 1990. That was the name of the audio video store next door. And Pallucci vacated his premises in August of 1990. He moved to a much nicer store. When the plaintiff sued to collect the rent for the remainder of the term, he asserted constructive eviction as a defense. So the issue at the center of this case really was that Pallucci did not vacate the property. So he didn't surrender the property. He stayed and he renewed his lease for 6 years. Now, constructive eviction can't exist where the tenant doesn't surrender the property. So he may have complained and complained and complained, but he didn't leave. Now, when would he have had to have left? He's not required to vacate immediately, but he's entitled to some reasonable time, but the court didn't feel that the time that elapsed was reasonable. I think it was 5 years? Right? So as a result, the court held that, excuse me, the level of interference was not substantial enough to trigger the constructive eviction. And the argument was that if it had, he would have left. The court also found that he had waived his right to argue constructive eviction by staying. So the court wanted to know, if the noise problem was so bad, why did he stay? So, in actuality, I should correct myself. The court didn't actually rule on whether or not the noise was substantially enough, because they ruled, but they did suggest that they would have ruled in his favor had they had considered the issue. Instead, they said that we're not even going to address the question because we find the defendant waived any claim of constructive eviction by remaining on the premise. All right, we're going to skip over some of these questions because we don't have a ton of time left. I wanted to go over the constructive eviction hypotheticals, though. All right, so can the tenants below vacate the premises and successfully assert the defense of constructive eviction? All right, hypothetical 1. A enters into a 10-year term of years tenancy in B's commercial office building in a southwestern state where she plans to open up an accounting firm. The lease states that B will provide air conditioning, but it says nothing about the required temperature. When A takes occupancy, she learns that B's building policies to ensure that the office temperature never exceeds 78 degrees. B explains that this is an energy conservation measure. As a result, A's employees are frequently hot, sweaty, and short-tempered. An expert consultant finds that their productivity level is 4% lower than it would be at 72 degrees Fahrenheit. B refuses to change his policy. Could the tenant vacate the premise and assert the defense of constructive eviction? Make sure to also explain why. This is a close case. So you need to find two things. First of all, was there an omission? And was that omission, and did that omission result in substantial interference? Well, arguably here there is an omission, right? The landlord fails to listen to what the tenant needs, and they arguably have breached the contract. But we would still have to show substantial interference. Now, because the contract is silent, they could look at this consultant's report and say 4% is a pretty large percentage of decreased productivity. You also could look at government standards, industry standards, to see what they are. And in fact, the Occupational Safety and Health Agency, OSHA, would recommend that the temperature range be between 68 degrees and 76 degrees Fahrenheit. So the plaintiff could use that to her benefit. I'm sorry, A could use that to her benefit. But this one is a close case. So if you went the other way, I think as long as you made strong arguments, you would be fine. All right, constructive eviction hypo 2. C enters into a year-to-year periodic tenancy for a retail store space in D's shopping center. D is aware that C plans to use the premises to operate a Christian bookstore. 2 days after C takes possession, D leases the adjacent store space to E, who immediately opens up a pornographic bookstore. C's business is doing poorly, and some customers have complained about E's adjacent store. D refuses to do anything about E's bookstore. Can C vacate the premises and assert the defense of constructive eviction? I don't think that C would be able to, or C would be successful in a constructive eviction defense here. And here's why. First, there's no wrongful act or omission by the landlord. There's nothing in C's lease that restricted D's ability to lease the property to a tenant. None of the other omissions that are listed on page 480 are relevant. You don't have any nuisance based on the facts. Now, if there is nuisance, then we would have another argument here. But based on the facts, there isn't any nuisance. Second, we don't have any evidence that D's decision to rent to E substantially interfered with C's business. We see that the business is doing poorly and that some customers have complained about the store, but we need to have more direct evidence about loss of business. And I guess you could even potentially argue that that having the store next door maybe brought business to C. Anyway, it's a very tenuous argument here. So that's it for this section. Next, we're going to talk about the implied warranty of habitability.